I'd like to thank the sponsors for being here this morning. We have some who are online, so to accommodate them, I'm going to take these bills out of order. But first, before we get there, I have here the sign-up sheet for anyone who would like to sign up to speak on today's bills. If you have not signed this sheet, please raise your hand. All right. Representative Taylor did. You just raise your hand when it's your bill and you can speak then, okay?
All right, thank you.
Actually, I'll let you speak and present your bill at the appropriate time.
Okay.
With that being said, since we have some people online, Representative Taylor, I'm going to go ahead and take Representative McKnight's. And what I'm going to do is, since we have an hour, I'm going to evenly divide the time. So if I tell you when your time's up, just prior to, I'll tell you. Okay?
Yes, sir.
All right. With that being said, House Bill 4949, Orders of Protection. Representative McKnight, if you would tell us something about your bill.
Thank you, sir, Mr. Chairman. Good morning, members of the committee. This bill seeks to create a way of getting orders of protection in South Carolina. It will create a uniform system of getting them. This bill is mirrored closely after the law in North Carolina, and what it does is a person can appear ex parte, meaning without the other party present, before a magistrate and get a 7-day ex parte order of protection. That order will require that both parties come into court for a hearing in which the magistrate court can then listen to both sides, and the magistrate court can then decide to issue a protective order for up to 1 year for the parties, and that order is subsequently modifiable by any family court proceedings. What we have here in South Carolina is in different counties, they issue orders of protections in different ways. Williamsburg County, you're required to have 3 incident reports. Some other places are in other ways. And then there's the method of getting one in family court. The necessity that brought this is particularly, and I'll just give you a little lay it out for you all, with a young lady, her name is Taylor McFadden Robinson. She was brutally murdered in her home by her husband with her 2 children present. She had gone to the family court, laid out all the specific instances in which her ex-husband had kicked in the door, threatened her, tried to run her over with a vehicle, and the judge still denied the order. He subsequently issued a statement in the media saying, well, she didn't come in and say she feared for her life. I understand that some people will say this is just an order, things can happen anyway, but we need to give our citizens the means of protecting themselves. I think that this satisfies our requirements for due process, in that the ex parte order is only 7 days, and for someone to get the order of protection beyond 7 days, they've got to come into court and have a hearing in front of that magistrate. And again, if it needs to be modified, or there's a subsequent family court proceeding in which the facts necessitate that the order needs to be modified or goes away, there's ways for it to go away in that manner too. So I don't want to talk up all of our time, but I would like to acknowledge the ladies of the Florence Alumni Chapter of Delta Sigma Theta Sorority Incorporated. They have come to the State House in person when we were supposed to have this hearing, and now they are present. They are from the city where Ms. McFadden lived, and they are adamant about their desire of having this law passed. It's time that we take domestic violence seriously here in South Carolina. I personally know, and I'm not counting Taylor, I personally know 10 women that have died at the hands of their husbands and their boyfriends. And I don't want to see another lady have to go through that. So, gentlemen, I'll take any questions if there are any.
Go ahead, Representative Hyde.
Representative McKnight, I appreciate your bill. Did you know that I practice in family court quite a lot? And I've certainly observed problems with this kind of issue before, because it often is too late, right? And so one question, just procedurally, this relates to family court orders of protection as well as civil orders of protection.
It's not a family court order of protection per se. What it allows for is, let's say a judge grants this order, not the ex parte, but the permanent order. And let's say there's a filing in family court, dad files, mom files. That order, even though it originates in magistrate court, can now be modified by the family court. So it's not like because we're dealing with two different venues and jurisdictions. I don't want to preclude a family court judge, who we all acknowledge has greater training and expertise than most magistrates, that they can then come in, make rulings, and modify it as they see fit.
Well, I commend your efforts, because I think one of the shortcomings in family court is often I've had clients tell the judge what might happen. And the judge says, well, you know, it hasn't happened yet, I can't do anything to help you, and then something happens, it's too late. One informational piece I would offer up to help build your efforts is, I do know in family court, in fact, there was one CLE I attended one time, and it said, is the order of protection the new temporary hearing? And so we're always looking for subject to abuse, how people might manipulate, you know, and if they accuse somebody of something they haven't done, would there be due process protections afforded that person? And I know you're thoughtful of this.
Yes, sir.
And I just know as you go forward, that's something you might encounter along the path where people are going to be looking to make sure you have protections for people who didn't do something, but all of a sudden they find themselves, you know, in the corner.
I get that, and I can appreciate that. And I've had extensive discussions with members of the legislature who had some misgivings about the potential abuse of this. But what this does, it doesn't, again, this is outside of family court. If someone comes into family court and makes their prima facie case, you know, based upon what the standard of evidence is for a temporary hearing or a temporary order to be made, this has no bearing with that. They still have to come into temporary hearing with the affidavits necessary to provide testimony and get the order of the family court judge issued in that manner. So I'm comfortable with this. I practice criminal defense, and so from that standpoint, I'm looking at laws from the perspective of how could this be used to hurt someone. Again, it's an ex parte order for 7 days. If nothing happens, it goes away, and it's like it never happened. For it to continue, both parties have to come into court, and the person moving forward has to make a showing for it. So that, you know, we all love the Constitution. Due process is the hallmark, and I'm satisfied that we can meet the satisfied due process requirements with this bill. Thank you.
Very good. Thank you for that, Representative Hyde, and thank you too, Representative McKnight. Due to our time, I'm going to go ahead and ask the ones who are attending virtually, if we can go ahead and give it them. And Kim Gordon, can you hear me?
Yes, I can. Good
All right.
morning. Can you hear me?
Good morning. I'm sorry to be speaking at the same time. Thank you very much for attending this morning. And if you would, give us just a few minutes of what you want us to know about this bill. Thank you, ma'am.
Well, good morning, Representative McKnight and members of the Judiciary Committee. Of course, like you just said, my name is Kim Gordon. I live in the Florence area, and I support this House bill. Now, my reason for being here starts with my professional relationship with Taylor McKnight, but a dear friend who I looked up to and admired. We took this, I don't know if you can see it, in our agency. We tried so hard to get together to get a family, a real estate family photo, trying since December. We finally got it done, and I'm glad we did. This is the only picture we have of us as an agency. Taylor joined our team on January 27th and was taken from us on January the 23rd, tragically. And 27th, and it's right before her anniversary, her 5th year anniversary as a realtor. She was a rising star in this profession, always polite, encouraging, supportive, and amazing at what she did for her clients. She was an impeccable hard work, had a hard work history, and here are just her few accomplishments as a realtor. 155 units sold, closed over $25 million in sales, had numerous months of being the top sales or listing agent, and awarded the United Real Estate Sapphire highest sales award for consecutive years. She hosted numerous events for potential home buyers, including first-time buyers, and she also created a moving service for her clients and set her sons, Damari and Caden, up on their very own vending company. All of this before the age of 30. She was loved and respected by her colleagues and the community. But above all that, she was a good person, a good friend, and became like family to us. We had many conversations about her dreams and desires, what she wanted for her sons, and who she adored. They were the reason she worked so hard. She wanted to show them that anything was possible if you believe in putting in the work. The word that stood out the most for Taylor was, as a realtor, was that she was an advocate for her clients. She fought for her clients with the bat for them to ensure their dream of home ownership became a reality. We are here today to advocate not just for Taylor, but for the many other individuals who have found themselves and who will find themselves crossing the same path. Now, I did not want to be here today, and I wish we did not have to be here. I hope that no mother, father, sister, brother, child, or friend would experience what we all had to endure on January the 23rd. Taylor's sons had their first football game a few Saturdays ago. She would have been there. They will have more birthdays, graduations, and life-changing events that I know they wish you could attend. I ask you, and I beg you to move this bill to the floor for a vote. Let's not allow another parent, friend, or child to lose a parent to this type of violence, but allowing magistrates to issue ex parte orders of protection in certain circumstances. And to amend sections 20-4-30, 20-4-50, and 20-4-90, all relating to orders of protection, so as to make conforming changes and for other purposes. Right now, Taylor's sons have lost both parents, and a community has lost an advocate who fought for them, and I am here to fight for her. Thank you for your time and your consideration on protecting others just like Taylor.
Thank you very much, ma'am. Thank you for what you had to tell us. The other speakers, just in the interest of time, about 3 minutes each, because I want to give everybody the opportunity to speak who is here online. Next, we have Valerie Lester. Can you hear me, Ms. Lester?
Yes, sir. Can you hear me?
I can. I am just really surprised how well this online meeting is working. So far, there have been no problems. So thank you very much. And if you would, tell us what you want us to know. And thank you for being here. And like to hear from you. Thank you.
Thank you. Greetings, Chairman Chris Murphy. My name is Valerie Lester. I'm a 30-year resident of Florence, South Carolina, and I appreciate the committee's time today to listen to my support of House Bill H 4949, Taylor's Law, the streamlining of how orders of protection should be handled and issued statewide. I'm in support of this bill for various reasons. But first, because all of South Carolina should approach and review the issuance of orders of protection along the same format. The citizens of South Carolina should know that regardless of whatever municipality they reside, in their request will be reviewed the same way. Taylor McFadden Robinson was my granddaughter's godmother. She was my daughter-in-law's best friend, and she was a beloved member of our extended family. Today, I want to say that Taylor deserved better, and this bill will be the start of that. Our perception is our reality. That being said, many citizens of South Carolina live in the reality of fear on a daily basis. Fear of our significant others, fear of our living conditions, fear of what may happen is real. The family courts in South Carolina deal with a lot of issues concerning the family, but an order of protection is an urgent need that should be addressed immediately. No one should have to wait for a backlog of family court issues to feel safe. Taylor is not the first that because the fault of a few is the fault of us all, have let fall into the cracks of the family court and or the judicial system. But let's take steps for Taylor to be the last. Please do not let this bill die in committee. Please vote in favor of Bill H 4949 and to advance the bill to the General Assembly so that it may become law. Time is of the essence. Taylor deserves better. The citizens of South Carolina deserve better. I deserve better. Thank you. I would like to thank the Judiciary Committee for the time allowing me the opportunity to speak. Again, a concerned citizen, Valerie Lester.
Thank you very much. Thank you for those words, ma'am. Next on the list, we have, looks like we have Miss Perry. Would you like to speak to us, ma'am? Okay, you're just attending?
No, I wouldn't. I'm just here in support of the bill and in support of you all moving forward. I think adequate.
All right, thank you very much. Next, we have Miss Williams virtually. There you are.
Good morning.
Go ahead and tell us a little bit about what you wanted to tell us. Thank you.
Thank you. Good morning, Representative Chris Murphy and members of the Judiciary Committee.
Just so y'all know, my name is Jeff Johnson. I'm the chairman of this subcommittee, criminal laws.
Oh,
That's
I
a lot
do
better.
apologize. I do apologize.
No worries, no worries. Thank you, ma'am. Please continue.
Okay, again, my name is Shatisha Williams. I live here in Florence and am a constituent who supports House Bill 4949 to amend the Code of Laws of South Carolina 1976 by adding section 2435 so as to follow magistrates to issue ex parte orders of protection in certain circumstances, and to amend sections 20-4-30, 20-4-50, and 20-4-90, all relating to orders of protection, so as to make conforming changes and for other purposes. In Florence, South Carolina, on January 23, 2022, Taylor McFadden Robinson was allegedly murdered by her estranged husband after twice attempting to gain a protective order against him. It is my concern that current law calls for a person to have committed at least 2 acts of stalking, harassment, or other threatening behavior against the complainant before one can be protected, according to the South Carolina Code of Laws petition for an order of protection. Unfortunately, she was not afforded a second opportunity to save her life. This bill is most important because national statistics tells us that for intimate partner violence, 65% of all murder-suicides involve an intimate partner, with 96% of the victims of these crimes are female, according to the Violence Policy Center. These statistics have hit our state of South Carolina. According to the 2020 South Carolina Domestic Violence Fatality Report produced by the South Carolina Attorney General's Office, 21 of 46 counties reported 1 or more domestic homicides in 2019. Of the domestic homicides reported, 86% of the victims were women, and 79% of cases, a gunshot was the primary cause of death. These are startling statistics for me, as I hope they are for you. My mission is to address issues that impact the communities I serve, and I know domestic violence obliterates the well-being of women, which in turn leads to the destruction of the family unit, which affects the mental, emotional, and physical functioning of women, men, and children. Taylor was not only a beautiful professional that was an involved member of our community, but she will also be a missed member of our community. The lives she touched will never be the same. In closing, it is incumbent upon you to vote for this bill to move out of committee for the General Assembly to continue the process of it becoming a law of the great state of South Carolina for the greater good, which is saving lives. Thank you, Representative Chair and the committee, for the opportunity to speak.
Thank you very much. Thank you, ma'am. All right, next we have Miss Laura Hudson, who has signed up to speak. And if you would, Miss Hudson, identify yourself and who you're with, and if you would, tell us what you want us to know in about a minute.
Good morning. My name is Laura Hudson. I represent the South Carolina Crime Victims Council. First, I want to thank Representative McKnight for this bill. I'd like to thank the ladies that have spoken so eloquently. I echo their comments. I echo Representative McKnight's comments. One of the things that the committee needs to keep in mind is that it's very difficult to get into family court, and giving this over to magistrates is very important, and I hope that you'll pass this bill. Thank you.
Okay, next on the list, we have Kitty Sutton. Tell us who you are and who you're with. Thank you.
Thank you so much. I'm Kitty Sutton. I'm the Executive Director of the South Carolina Association of Criminal Defense Lawyers, and thank you for having me here today. Certainly, we support this bill in many aspects, but one unintended consequence that we would like for you all to consider before moving forward is concerning property rights. An unintended consequence might be a situation such as having a petitioner come in for the ex parte order and having that be granted and having the defendant be ordered to stay away. And if the defendant is in fact the property owner, then the petitioner would be allowed to remain in the property while the defendant would be ordered to stay away. There's been a case or two reported whereby the petitioner ended up selling property out of the house, selling the defendant's car, and things like that. So our proposed solution would be to have an establishment of the fact that the petitioner is a property owner or a leaseholder of the property, establishing just the property rights there so that property is not sold along the way. That would be the collateral effect of that. But certainly as far as victims' rights, we support that part. Thank you.
A little bit more time to look at this bill. Representative McKnight, I thank you for your work on this bill and what you have to say. And thank you for your work. Any motions?
Mr. Chairman, I move to adjourn debate.
Any motion is adjourn debate on House Bill 4949. All in favor say aye.
Aye.
All opposed? Ayes have it. Thank you very much. Thank you, Representative McKnight.